Welcome to the Chapter 2 on Breach Notification and Response with the Digital Personal Data Protection Act, 2023, DPDP Act. Data breaches are among the most critical challenges in the realm of data protection. Data breaches are one of the most serious concerns in data protection laws. The Digital Personal Data Protection Act, 2023, DPDP Act, outlines specific provisions for the notification, response, and handling of data breaches to protect the rights of data principals and ensure compliance by data fiduciaries. This chapter delves into the breach notification requirements under the DPDP Act, the timeframes for reporting breaches, and the consequences of non-compliance. Data breach notification requirements. A data breach is defined as any unauthorized access, acquisition, disclosure, alteration, destruction, or loss of personal data that compromises its confidentiality, integrity, or availability. Under the DPDP Act, data fiduciaries and data processors are obligated to take immediate action upon discovering a breach. Key provisions under the DPDP Act. 1. Notification to the Data Protection Board. Section 8(6) of the DPDP Act mandates that, in the event of a personal data breach, the data fiduciary must notify the Data Protection Board of India, DPB, as soon as possible. The notification should include the following details: the nature of the breach, the personal data involved, the remedial actions already taken or intended to mitigate the effects of the breach, the potential risks to the data principal S. This timely notification ensures the board is promptly informed and can intervene if necessary to protect affected individuals. Notification to data principals. Section 8(6) also mandates that if the breach is likely to pose a high risk to the rights and freedoms of data principals, e.g., exposure of sensitive data like financial information, the data fiduciary must notify the affected individuals. The notification must inform data principals about the nature of the breach, provide clear instructions on how individuals can mitigate the potential harm, e.g., changing passwords or freezing accounts. Include the contact information of the Data Protection Officer, DPO, or the person responsible for handling the breach. Illustration: if a financial institution experiences a breach where customer account details are accessed by unauthorized individuals, the institution must notify both the Data Protection Board and the affected customers. The notification will contain the nature of the breach, e.g., unauthorized access to account numbers and transaction history, and advice on securing accounts, e.g., password changes. Timeframes for reporting breaches. The DPDP Act sets strict timeframes for reporting breaches, ensuring timely notification to both the Data Protection Board and the affected data principals, thereby minimizing potential harm. 1. Notification to the Data Protection Board. Section 8(6) requires that the data fiduciary must notify the Data Protection Board within 72 hours of becoming aware of the breach. This strict timeframe ensures the board can assess the breach and take appropriate actions swiftly. 2. Notification to data principals. If the breach involves high-risk personal data and is likely to result in significant harm to data principals, the data fiduciary must notify the affected individuals without undue delay. While the DPDP Act does not specify a fixed time limit for notifying data principals, it implies that notifications should occur immediately after the breach is identified. Illustration: for example, a cloud service provider experiences a breach that exposes users' names and email addresses. The service provider must notify the Data Protection Board within 72 hours of the breach. If the breach involves sensitive data like passwords or health-related information, the provider must also notify the affected users immediately. Consequences of data breaches. The DPDP Act holds data fiduciaries and data processors accountable for breaches, imposing serious penalties for non-compliance with breach notification requirements. This serves as both a deterrent and a mechanism to ensure timely corrective actions. Penalties and enforcement. 1. Failure to notify the Data Protection Board. Section 33 of the DPDP Act outlines the penalties for failing to notify the Data Protection Board within the 72-hour timeframe. The penalty will vary depending on the severity and impact of the breach, including monetary fines. 2. Failure to notify data principals. If a data fiduciary fails to notify affected data principals or does so in an inadequate or untimely manner, it can face significant penalties under Section 33(1). The penalty is determined based on factors like the gravity of the breach and whether sensitive data was involved. 3. Failure to take remedial action. Data fiduciaries must take immediate and effective remedial actions following a breach. If the fiduciary fails to act promptly to mitigate the damage caused by the breach, it may face additional fines or sanctions. Example: if a retail company experiences a breach where credit card information of customers is exposed, and the company fails to notify the Data Protection Board and the affected customers within the 72-hour period, the company could face a penalty of up to 200 crore, depending on the scale and severity of the breach. Consequences for data principals. While penalties are primarily focused on data fiduciaries and data processors, data principals may also suffer harm due to a breach. The DPDP Act empowers data principals to seek remedies for any damage or distress caused by a data breach. Direct complaint to the board. Data principals can lodge complaints with the Data Protection Board or seek legal remedies through the court system if their data is compromised. Key takeaways. 1. Breach notification. The DPDP Act mandates that data fiduciaries must notify both the Data Protection Board and affected data principals when a breach occurs. Notifications must include detailed information about the breach and steps to mitigate potential risks. 2. Timeframes for notification. Data fiduciaries must notify the board within 72 hours and inform the affected individuals immediately if the breach is likely to cause high risks to their rights and freedoms. 3. Consequences of non-compliance. Failure to comply with breach notification requirements can result in severe penalties, including monetary fines, reputational damage, and legal consequences for the data fiduciary. Data principals may seek compensation for damages caused by breaches. Through these provisions, the DPDP Act ensures that breaches are handled promptly, responsibly, and with transparency, safeguarding the rights of data principals and promoting trust in data processing practices. Thank you for joining this session. In the next lesson, we will explore the penalties for non-compliance, diving deeper into how this vital code operates. See you soon. Don't forget to subscribe to our channel for more valuable legal insights and updates. youtube.com/@prolegalminds. If you have any legal questions or need assistance, visit us at prolegalminds.com to connect with our expert team. We're here to help you navigate the complexities of the law with confidence. Stay informed, stay empowered. See you in the next session.